mentioned in the original presentation I did a little while ago was that the process of selling your business, you have to sort of be right and ready to go realistically. So what happens in practice is that you've been working really hard for 10 years and you just keep waiting for someone to knock on the door. Probably that never happens now. So you've been waiting for an email, or more likely a telephone call from a lawyer or an accountant saying, listen, we might have someone interested in your business, how will we start the process? And you say, thank God for that. How much, you ask me how much they're going to pay, they said we don't know, maybe 20 or 30 mil, so you've already started looking at the real estate guide for Nice in France, or that boat you've already wanted. You can see yourself sailing on the boat with all your friends. So you've mentally moved to a sale. But then the due diligence that is applied to your business is intense. Now what I mean by DD, it'll be like, I won't go over the previous presentation, the IP, maybe tax, that employment, it just goes on and on, but you are going to get a hell of a lot of due diligence regarding privacy and data, because the lawyers will be involved and they'll have to write a report. And these days, with the sensitivity around privacy and data, if they don't like what they see, then they'll walk away. Actually, I'm just looking at my pen, so this isn't contrived. So as a prop, not prop tech, as a real prop, CoreLogic, their lawyers or accountants or some sort of brokers approach you, want to buy your business. It sounds fantastic, you think great, but they will do a massive amount of DD. You don't want bad reports. And what happens in this space is you don't get like an E minus, you haven't quite passed the test, and then the potential purchaser says, look, can you go away and tidy up your data? Can you go away and tidy up your privacy? It will not happen. It will not happen. They'll just walk away and they'll look to buy maybe one of your competitors or someone else. So you've got to really try and get this correct on the way through. I think I'd be fairly right in saying that there's not necessarily a lot of cost to get this to get the privacy data right. So if you had a client who said they wanted to make sure they're compliant, what would you be telling them they had to do?
So if you've got a business which is looking to be in the best possible shape to sell the business down the track, before you get to the sale process, which is your forte, John, before you get to that process, they need to actually do a internal due diligence on whether they've followed the correct procedures when onboarding the individuals. Make sure that they've given the proper disclosures, got the correct consents if needed. So if they haven't, that all is not lost. You can seek to re-engage with those individuals and make sure you cleanse your database and have only those individuals who have positively been given the right disclosures or consents. And if some people are not in that category because years down the track you don't know how those names were actually collected, there's no audit trail, the safest thing to do would be to remove them altogether.
Yeah, okay. So not that complicated. It's not in the category of urgent. It's sort of do it as you're going along, but sort of worth doing rather than trying to catch up if you've had some interest in your business. So, but do you want to explain, like if you were perhaps a person who probably hasn't worried about this too much because that's the person who might get prosecuted, what the penalties actually are, how they figure them out? Yeah.
Thank you, John. That's a great question. And it's really worth noting that in December 2022, just not very long ago, just over 6 months ago, the penalties for repeated and serious interferences with privacy were significantly ramped up. Now it's a high bar, serious and repeated breaches of interference with privacy, but it's still really important to keep in mind that if you're a company and you fall within that category of having committed a serious and repeated breach of privacy, the penalty that could potentially apply to you as a company is the higher of, so really it's the higher of $50 million, or alternatively, a multiple of 3 times any benefit that you obtained as a result of your contravention of the Privacy Act. Or alternatively, if you can't determine that benefit, the value of the benefit you obtained, the alternative is that 30% of your annual turnover for a defined period is potentially payable by you. So it's the highest of those 3 things. $50 million, 3 times the value of the benefit you obtain as a result of the contravention, or thirdly, 30% of your adjusted turnover for the relevant turnover period. Really serious stuff.
Yeah, okay, for sure. Yeah. We've spoken a little bit about this before, and I think I'm sort of on the wrong tram here when some even say to clients, do you own this data? How are you allowed to deal with this data? But you're saying that's not really what it means. It's more a use thing rather than sort of like owning a database. Yeah.
Yeah, and thank you, John. That's a great question. I totally get why players in the industry talk about owning data. It's a good shorthand way of explaining that a particular company, let's say a PropTech, is entitled to deal with that and sell it and commercialize it. So I totally get why people, as a shorthand mechanism, say they own the data. That's fine. Technically, though, it's not capable of being sort of sold in a sale like a can of baked beans or something tangible. And the reason for that is there are a number of different overlays. So you might have a database with names of contacts or leads or past customers. That cannot automatically be transferred and commercialized by the person to whom you've transferred it. And the reason for that is twofold. First of all, that is most likely going to be personal information about people that's contained in that database. And that's because the definition of personal information includes information or an opinion about an identified individual, or an individual who's reasonably identifiable. So it doesn't have to be anything sensitive like a credit card number or health information or anything like that. Just the name sitting there in the database with an email address or a physical address and a phone number is personal information, which then means that if you as a seller want to sell that to somebody else, the somebody else who's buying it needs to work out whether in their hands they can use it in the same way that the seller used it.
Yeah. So it's got to be when it's in their hands and they're trying to sell it as a asset, probably the major asset in their business, they have to be able to explain that they've complied with privacy and why they can use it.
One thing that's really important to keep in mind is that at the moment, as everything we've been talking about relates to the handling of personal information, in March this year, the Attorney General in Australia publicly released a review which recommends 2 things. First of all, broadening the definition of personal information to make clear that certain types of things which might not otherwise be considered to be personal information are personal information, like device identifiers and things like that. So that's really critical. It means that you might be sitting on data that you don't think is personal information but will be treated like personal information going forward. That's one aspect, the broadening of the definition of personal information. Secondly, there is a proposal to expand the privacy law to regulate the targeting of particular demographics and individuals where you might not actually know that it's Mary Smith that you're targeting. You just know that someone's in a particular demographic or has clicked on particular ads and so on, and you try to approach them. And that will be covered by the Privacy Act, even though technically it doesn't involve personal information. So it's critical to keep that in mind when considering the data versus personal information distinction.
So the other night, again, when we were talking about this, and Abraham, who works for me, was saying that that there might be an issue with, say, approaching 20 and 30-year-old males to join a gym when you're just picking up data on them, that there may be issues with just approaching just a general demographic.
Indeed. So if, for example, you have browsing history that you know that by a process of deduction, a particular IP address has been accessing websites, etc., which makes it more likely than not that they are in a particular demographic and they're likely to be interested in joining a gym or interested in French clocks or any such thing. Targeting those individuals, even though you as the marketer don't know who they are, you don't know their name, will potentially be regulated under the Privacy Act going forward.
Okay, we'll put some details of us
Yeah.
here, and as I said, David might be able to help with just a bit of a how-to or what to do sort of guide if you want anything like that. Maybe later in the year we might run a more intense workshop, probably face-to-face here, probably.
Indeed.
Yeah, which some of you may want to come along to. We'll probably do some details. So thanks for your time.
Thank you very much.